हेलो बच्चों, लेट्स सी पैसेज 2. इट टॉक्स अबाउट अ टॉर्ट इज अ सिविल रॉन्ग. टॉर्ट कैसा रॉन्ग है? एक सिविल रॉन्ग होता है फॉर विच द लॉ प्रोवाइड्स अ रेमेडी. प्रोबेबली द एसेंशियल थिंग टू वरी अबाउट द टॉर्ट इज दैट टॉर्ट ओनली appears in civil courts, which means that there is no criminal liability. There is absence of criminal liability from a tort. Employers are vicariously liable under the respondeat superior doctrine for negligent acts or omission by their employees in the course of employment, sometimes referred as scope of employment. For an act to be considered within the course of employment, it must be directly authorized. It must be either authorized or so connected with an authorized act that it can be considered a mode or through an improper mode of performing it. तो अब एम्प्लॉयर जो वाइकेरियसली लाइबल होते हैं वो या तो डायरेक्ट हो सकते हैं कि वो विद इन द कोर्स ऑफ एम्प्लॉयमेंट हो, अब उसके लिए वो ऑथराइज्ड है या फिर कनेक्टेड विद ऑथराइज्ड एक्ट है. लाइबिलिटी इनकर्स बाय अ बिजनेस फॉर एक्ट्स अदर देन दोज बाय इट्स एम्प्लॉयज. दिस पर्टिकुलर सिचुएशन में अराइज व्हेन द इंडिपेंडेंट कॉन्ट्रैक्टर इज हायर्ड. अब इंडिपेंडेंट कॉन्ट्रैक्टर की लाइबिलिटी कैसे होती है? दिस बिजनेस कैन बी हेल्ड लाइबल फॉर द नेग्लिजेंट एक्ट ऑफ द कॉन्ट्रैक्टर टू द एक्सटेंट दैट इट्स रिप्रेजेंटेटिव्स गिव्स डायरेक्शन. क्या या तो आप रिप्रेजेंटेटिव्स हैं जो डायरेक्शंस दे रहे हैं या तो आप कंट्रोल एक्सरसाइज कर रहे हैं ओवर सच कॉन्ट्रैक्टर्स एम्प्लॉय. तो कोर्ट समटाइम डिस्टिंग्विश बिटवीन एन एम्प्लॉयज detour or frolic. For instance, an employer will be held liable if it is shown that employer has shown on a mere detour in carrying out their duties, whereas an employee acting in his or her own right rather than employer's business is undertaking a frolic and will not subject the employer to liability. तो फ्लॉरिक जो होता है उसमें सब्जेक्ट टू लाइबिलिटी नहीं होता है, बट अगर आप डिटूर कर रहे हैं तो एम्प्लॉयर के बिजनेस के हिसाब से तो उसमें लाइबिलिटी आती है. Vicarious liability extends to those acts done in the course of the agency where the act is following the instruction of the master. यहाँ पे आप instruction of master follow कर रहे हैं. It does not extend to the extent. It does not extend to the extent. अब कौन कौन से में नहीं लगता? Acts done outside the course of agency, acts done after the agency is terminated. तो इन दोनों केसेस में नहीं लगेगा. अब हम बात करें कि when a person engages into another act on his behalf, it creates a relationship between the principal and agent. Since the principal put the agent in a situation where a tort was committed, the principal is vicariously liable for the same. क्योंकि आपने अपने एजेंट को उस सिचुएशन में डाला इसलिए आप भी लाइबल होंगे. A principal would be liable for all the acts of an agent when they are expressly delegated to do them by the principal. Given express authority to do certain tasks also includes implied authority to do all the things in a proper and usual manner necessary to perform the job undertaken. Following are the steps to check the principal. अब आप principal agent relationship establish कर रहे हैं तो इसको check कैसे करेंगे? तो let's see the test. First is express an appointment and publish the same to the outside world. कि आपने appoint किया है सामने वाले को और आपने उसको publish किया. Second है implied actions, या तो आपके actions और conduct ऐसे हैं जो impression दे रहे हैं कि सामने वाला आपका agent है. In the case of emergency, appointment by necessity, a distinguishing characteristics of MS relationship is that agent has the power to enter into contracts on the behalf of the principal. Let's see the questions now. Question number 6 says XYZ Corporation hires an independent contractor. यहाँ पे कैसा है? Independent contractor to perform the maintenance work of their premises, while the job of the contractor employs accidentally causing damage to the neighboring property. Will XYZ Corporation be held liable vicariously for the employee's action? Let's see the options to find the correct. Option number A says yes, because XYZ Corporation should have exercised more control over the contractor's employer. यहाँ पे जो employees हैं उसमें XYZ का कोई control नहीं है, hence यहाँ पे liability नहीं आएगी. B says yes, because the contractor's employer was acting within the scope of employment. Again a wrong option. They were not under the scope of employment as there was no control exercised by the XYZ Corporation or its employees. C says no, because the contractor's employer was not directly hired or supervised by the XYZ Corporation. This is the right option, because contractor's employee were working in the behalf of independent contractor and were not under the direct control of XYZ. corporation. D says no because the damage occurred outside the course of agency relationship. This is a wrong. There is no agency relationship being established here. 7 says ABC company employed John as a delivery driver. One day while making a delivery, John decides to take a detour. Take take a detour to run a personal errand. During the detour, he negligently causes a car accident. Will ABC company be held vicariously liable for the accident? Option number A says yes because John's detour was still connected with the employment duties. This is a wrong option because he detour was for a private reason of running personal errands, and hence it cannot be considered as a job related to the employment duties. B says yes because ABC company should have exercised strict control over John's action. This is a wrong option because control is over when he detours. Detour is for the private purpose, and hence the employer cannot be held liable. C says no because John was acting on his own and not on the behalf of ABC company. This is a right answer because when he detoured, he escaped from the employment course of employment and was running as a private individual having individual rights and duties. D says no because the accident occurred outside the course of John's employment. This did occur outside the course of John's employment, but it was also not on behalf of them, so this was not something which can be held vicariously liable. So this is a wrong option. Let's see question number 8. It says DEF Corporation has an independent contractor to install a new security system. The contractor's employee who is responsible for the installation accidentally damages DEF Corporation's property in the process. Can DEF Corporation held liable for the employee's action? Here option A says yes because DEF had control over the contractor's employee during installation. No, there was no direct control, hence wrong option. B says yes because the contractor's employee was acting within the course of their agency relationship. No agency relationship is established here, so again a wrong option. C says no because the damage occurred after the completion of the agency relationship. This is also a wrong option because there is no agency relationship. D says no because the contractor's employee was solely responsible for their negligent action. This is right because they were not under the direct control of DEF Corporation and they were acting independently as independent contractors employee. Let's see ninth question. Ninth question says X company employs Sarah as a sales representative. As a part of her duty, Sarah has the authority to enter into contracts with client on behalf of X company. During one such interaction, Sarah fraudulently misinterprets X company's product to a client, resulting in financial losses to the client. यहाँ पे सारा ने फ्रॉड किया है वेल एक्टिंग ऑन बिहाफ ऑफ द एक्स कंपनी. तो अब क्या है, एक्स कंपनी को हम वाइकेरियसली लाइबल मान सकते हैं फॉर दिस फाइनेंशियल लॉसेस. लेट्स सी द ऑप्शन. Option number A says yes because X company granted Sarah the power to enter into contracts on their behalf. This is a right option because the company did grant the authority to Sarah to act on their behalf and enter into contract, so they can be held vicariously liable for any contracts which Sarah enters into. B says no because Sarah's fraudulent action were outside the scope of her employment. Just because she conducted a fraud, we cannot say that you were not under the scope of employment. Whatever she did was under the scope of employment and she did while she performing the authority that was exercised by the X company. So this is a wrong option. C says yes because X company could have exercised more control. Again a wrong option. And last option, that is option number D, that says no because the losses were solely caused by Sarah's own wrongful conduct. This is also a wrong option. Although this was own wrongful conduct, but it was well within the scope of employment and hence vicarious liability of company X will arise. Let's see the last question. PQR Corporation hired James as security guard to patrol their premises. One night, James decides to leave his post without permission to run some personal errands. अब personal errands की बात हो गई. During his absence, a theft occurred in his premises. Will PQR corporation be held vicariously liable for the. Let's see the options. A says yes because the James action can be considered a detour within the scope of his employment. This is not a detour, but it is instead a frolic. Frolic is when you are leaving the course of employment for your personal reasons, and here the same happened, so the company or corporation is not liable in such cases. B says yes because PQ or corporation should have exercised strict control over James' whereabout. This is again a wrong option. Strict control होना चाहिए था या नहीं होना चाहिए था is not our concern. What has happened is something that we need to see. C says no because James was not acting within the scope of his employment during the absence. James did escape the course of employment when he left the post for running his personal errands, and this was leaving behind the agent's vicarious liability thing. So here PQR cannot be held liable for theft, and this is a right option. D says no because the theft occurred due to James' unauthorized actions. This is again a wrong option. Unauthorized actions nahi, these were rather out of the scope of employment because he went for private errands. So this is also a wrong option. All the best.